Thank you, counsel. Justice Thomas, anything further? Justice Alito? Justice Kagan? Justice Gorsuch?
Ms. Blatt, I kind of want to return to some of the questions I asked earlier. It seems to me inherent in C1 is a distinction between those who are simply interactive computer services and those who are information content providers. And so when we flip over to F, the distinction I glean from that is that if you're picking, choosing, analyzing, or digesting content, which is the bulk of what how you describe Google's activities in a search engine context, are protected, and that content must be something more than that. Providing content must be something more than that. Is that right, in your view?
I thought you were absolutely correct, and I think some of the amicus briefs do this. In terms of if you're looking at what is information being created or developed, there is that distinction. It can't be that you, by sorting, you created or partially developed the information. So I think you had it exactly right. I got a little upset when you talked about a remand that somehow the Ninth Circuit got it wrong.
Well, let's go there next then, because it seems to me that even under that understanding of the statute, there is some residual content for which an interactive computer service can be liable. You'd agree with that that's possible?
Not on this complaint, because
no, of course not on this complaint, but in the abstract, it's
absolutely
possible.
Correct.
Okay. And then when it comes to what the Ninth Circuit did, it applied this neutral tools test. And I guess my problem with that is that language isn't anywhere in the statute, number one. Number two, you can use algorithms as well as persons to generate content. So just because it's an algorithm doesn't mean it can't generate content, it seems to me. And third, that I'm not even sure any algorithm really is neutral. I'm not even sure what that test means, because most algorithms are designed these days to maximize profits. There are other examples. Justice Kagan offered some. The Solicitor General offered some where an algorithm might be contain a point of view, even a discriminatory one. So I guess I'm not sure I understand why the Ninth Circuit's test was the appropriate one and why a remand wouldn't be appropriate to have it applied, the test that we just discussed.
Because it's not, I don't think that was the Ninth Circuit's test. It was one sentence that was, maybe I think it mentioned it twice. It's basically, almost making fun of the complaint. The complaint doesn't.
Okay. So we're just disagreeing over how we read the Ninth Circuit's opinion. But if I read it that way, then would a remand be appropriate?
Well, I'm going to say no, because I don't understand how somehow that they have a bad complaint means the Ninth Circuit's worse off. When the Ninth Circuit said over and over and over, this is just the way you're organizing it, and the complaint never alleges there was something independently wrongful about the content. It never says these were colloquial recommendations. It just says because you previously liked this content. And one other thing, the complaint never even alleges that the YouTube ever recommended to in terms of even displaying an ISIS video to anybody who wasn't looking for it. I don't even know how you could get ISIS on your YouTube system unless you were searching for it. And the one
I certainly understand your complaints about the complaint. But if you don't think neutral tools, you're not defending the neutral tools principle either, as I understand it.
I'm defending it with respect to Justice Kagan's question, absolutely, because she's concerned about biased algorithms, and she doesn't have to worry about that in this case because they have neutral algorithms. They don't allege, and what they mean by neutral algorithms is neutral with respect to content. So there's
Thank you.
Okay.
Thank you.
Thank you.